Hi, welcome back. You have Michael Gullo and my partner Christina O'Shea, and today we're covering EUOs, brief overview. And this is part three. We're in section five of our training module, litigation strategies, no-show EUO summary judgment motions, and fraud summary judgment motions. What's required and how we proceed as defense counsel on these matters. I will share my screen so we can see our outline. So to begin, the no-show EUO. It's been pervasive throughout this educational series here, but we do need precise documentation. We try to be as perfect as possible. Actually, it needs to be perfect for us to be able to move forward. It's very technical and very specific. So in our summary judgment motions, we have a notice of motion, we have an attorney affirmation in support. We have our EUO scheduling letters as an exhibit, transcripts or the no-show. We have proof of mailing of the scheduling letters, proof of mailing of the denials, the attorney affirmations, the litigation examiner or adjuster affidavit for the timeliness of the denials is a separate document. Christina, other than those documents, that pretty much, as far as our summary judgment motions go, these are the documents that are in every no-show summary judgment motion.
Right. And we want to make sure that, we have our forms and there's a checklist that is a non-negotiable checklist of what we want to include on any given summary judgment motion. But for us, we do pay very close attention to the sometimes they change case by case. The general construct of a litigation examiner or adjuster affidavit tends to be the same from motion to motion. But if, like we were talking about earlier, if there's an address discrepancy or something, we want to explain that away based on
Right.
personal knowledge of that litigation examiner. And so those are nuanced things that we might change from motion to motion. We want to walk the judge through what address discrepancies we saw or why we sent them to multiple addresses.
Right.
If there's a transcript, as Mike pointed out earlier, we like that transcript or that motion rather to be in the name of the attorney that appeared at the EUOs. And if that's, let's just say, for example, Mike was on one EUO and I was on the other EUO no-show. Sometimes we like, again, just to play it safe and not lose on the technicality, to make sure there are those affidavits to attest the personnel knowledge or get those documents into evidence. The court can take judicial notice of those things, but it's a little more stringent than it is in arbitration, where the rules of evidence are a little bit more
Because
relaxed.
we need what they say, it's called proof in admissible form. Admissible form basically means an affidavit or an affirmation from an attorney. So while we can include the letters, obviously, as an exhibit to prove that those letters were actually drafted and mailed, that comes in the form of the admissible proof, which is the affidavit supporting that. Same with the denials. The denial itself as a document can be used as proof, but we do need the adjuster or the claim rep affidavit to show that that denial was generated and properly mailed on time.
Right. But those are generally the documents that we include.
Yes, and every one, those are the documents we need. Those are the precise, referring in the affirmations where we got the addresses from. So when we refer to proof of mailing and proper mailing, that also includes where we got the addresses from the NF2, and we include that as an exhibit so that we can show the court where we got the information from so that they can confirm that it's accurate.
And we're also presenting them with the denials themselves as well.
Yes, of course.
If we received any bills, we'll provide them with that information as well. We make sure that those are included.
And so later defective denials, obviously that's going to impact summary judgment motions. Late denials, it is a precludable defense unless you're in the first department, which follows a case unitrin. It's another section we can go into detail on, and you can go retroactive back to the date of the accident to deny the claim. But generally speaking, in the second department, where a good chunk of our files and litigation cases will be, and generally in AAA, they do not follow the unitrin rule. So we do need and want timely denials on these matters. So again, that's denying within 30 days of the last event, either the UO being held or the second no-show. In this
Right. And
particular
yeah,
situation, would be the no-show.
right. And, at this point, it's important to know we strongly suggest if there's a question from any examiner as to what date certain things should be getting out, we make ourselves available all of the time to have those conversations with the adjusters, um, just to make sure that those timelines are adhered to.
Mhm.
Oftentimes it could be as simple as a call to see if we
Yeah,
suggest getting that sooner, or, if we
right.
have time, we'll advise that as well. But,
Right.
we don't want to miss those marks.
No, they're critical. So the other option is we have the no-show summary judgment motion, and then we could potentially have summary judgment motions based upon fraud, based upon these various reasons. There are other stage accidents, a common material misrepresentations, exaggerated or unrelated injuries, treatment not being received. These are all reasons to potentially deny the claims for or deny portions of the claim or certain providers. In these motions, our threshold, our burden to prove fraud is a high one. Not only a reasonable suspicion of fraud, we really need to have our ducks in a row, so to speak, and every other paperwork has to be perfect. If we're using transcripts to prove our fraud, we want to go through the transcript and pluck out the page numbers and the line numbers that correspond to the statements that were being given or the inconsistencies that were shown. So a fraud summary judgment motion in a simple no-fault case can be voluminous. It can be substantial with two or three different transcripts, different denials. And of course, an SIU affidavit will go accompany that to link it all together in addition to the attorney affirmation. It's precise proof in admissible form, affidavits, affirmations from attorneys, affirmations from lay people are acceptable now, but we go with the affidavit. Um, we say often proven through circumstantial proof because a lot of times there's not that aha moment where somebody said, "Oh yes, I committed fraud." So it'll be circumstantially putting all of the pieces of the puzzle together to come together and say, circumstantially, if we look at this whole thing, it's fraudulent. Again, to sign transcripts after the EUO is held, the transcript will go to the claimant. If he's repped, it goes to the attorney, and we ask them to sign and return and make the changes that they need to be made on the transcript. If they send that back, great, that's our proof. If they refuse or don't send that back, we send a follow-up letter. If they don't comply after a certain period of time, it's deemed signed, and we can use that in court as if it was signed. Timely denials may or may not be required for fraud. For a staged accident, if an event did not occur, they don't require us to have a timely denial because there is no claim, because there was no accident. But to play it safe on any type of material misrepresentations or frauds, we would like to see those denials be timely. Some of the pitfalls to avoid, I mean, Christine, I know you deal with this a lot, especially in arbitrations with the time frames. Not sending it out within 15 days of the receipt of the bill.
Right. And those things, again, we are available for those specific case specific questions. There are little rules that are in our tool belt here in terms of, for example, if we didn't get that verification request out within 15, but we got it out within 17, then that extra 2 days just comes off the back end of our 30-day time frame to deny. So instead of 30 days, we'll then have 28 days.
The
And those
rules,
can get a little nuanced and confusing. So we won't really delve into that too much here.
that's the rules of the verification process, which is a seminar in and of itself,
Right,
for
right.
sure.
So, those are definitely, I think that might be the single most crucial pitfall to avoid is the timeliness of when these documents are going out, especially when we know we have a solid fraud defense. It's
Having
the most,
incomplete, ambiguous denials. We need to set forth in the denial reason why. We can't just say, "Oh, denied on fraud," and leave it at that. That's not gonna be enough.
right. And as Mike said earlier, we are more than happy then to even help drafting some of these, which we have done in the past. We know what the judges are looking for. And quite frankly, we know what the attorney's arguments on the other side are going to be. And so when we go into these cases, from the inception of the claims process and the handling of the claims process on the front end, we as attorneys are always looking at it on the back end. Well, are we going to get this into court? Is a particular judge going to go our way on this issue? Are they going to see a problem with this? What attorney is going to argue against technicalities? And like I said, it's wildly frustrating to
Yeah.
lose a motion on summary judgment for technicality or for something that could have been prevented
Right.
if these procedures were followed. And so again, if there's any question or confusion as to,
Let's talk about it.
yeah,
Pick up
let's
the
talk
phone.
about it.
Pick up the
Right,
phone.
exactly. Yeah, we're more than happy to do that.
Oh, to conclude our section here, moving into section 6, the SIU collaboration and red flags. I mean, SIU has their list of reasons why they would ask for an EUO, but some of the common reasons are, there are conflicting accident descriptions. The police report says one thing, our insurance says another thing, a statement taken says another thing. Accident close to the inception of the policy, 2, 3 days after, this raises red flags. Repetitive billing patterns where everybody in the car just needs the same shoulder surgery on the same day, things of that nature. Identity concerns, they know each other, how the occupants know each other, and prior accidents and their link to prior accidents. Suspicious behaviors, relationships, accident patterns, you know, different stories, all these things that can SIU takes a look at, evaluates, they have their case notes, and they say, wait a minute, something's not right. We want to pull this person in for an EUO to verify this claim. Christina, what do you think the most common reason for the EUO is to basically verify facts and treatment modalities?
Facts and treatment modalities. Again, if there's a laundry list of an ISO report that there's similar accidents, if this
Right.
person, a specific individual, has been involved in 10 rear end accidents, sometimes within the same calendar year, that's of course a red flag. And again, that's more of a exaggerated example, but those things do come up.
Mm.
We often see same treatment. It just so happens that every single person in the vehicle is receiving left shoulder surgery. So those are things, again, we want to compare the treatment of each of the individuals within the vehicle. They're all at the same provider. That's also a red flag.
All right.
We want to know how they found out about the provider to begin with, or how they found out about their attorney. Sometimes that's objected to, but sometimes we can get that information from
Yeah.
them. I mean, we pay attention to all of those things. I think, yeah, as you said, I think just treatment specifics and to verify the claims, the facts of the accident.
Mhm.
I think
And
that's what we're really going for.
And after the EUO and it's all said and done, I mean, these trigger rescission action, meaning the policy, go back to the date of the policy to cancel based upon material misrepresentations. It's possible. If we do that, say it's a rate evasion claim or something of that nature, we'd like to have an underwriting affidavit saying that the policy would not have otherwise been written, but for the information that if we knew this beforehand.
And that might seem silly, but just to interject, we have seen motions denied
Yes.
when they don't have that. So if we can't get an underwriter's affidavit, which sometimes is a little difficult to obtain depending on the
Mm-hmm.
circumstance, we like to say have at least from the examiner and see if that will fly in court. But something that says that the policy would not have been written
Yeah.
had they known about that fact.
And once we have these denials, we are going to either see, as far as the claim on the no fault end, we'll see no fault litigation matters in civil court or in the district courts out in Long Island. We will see AAA arbitrations, or on certain cases, we go with DJ action. We do have clients that like to do DJ actions on no-show EUOs. So this way they do the DJ action, the no-show EUO, it's an immediate motion for summary judgment in the Supreme Court. And then we use that decision saying that we don't have to cover for all of the other arbitrations and no-fault litigation actions. That process is, factual allegations in the complaint were very specific, a list of providers and their addresses, and we usually have their TIN numbers by that time. Service of process on the providers is generally done through the Secretary of State so that we can assure proper service. Sometimes the individual claimants are a little tricky, but we do have their last known addresses, so we will use those. Um, we do make motions to stay the lower court proceedings sometimes if there's a lot of them and the DJ is taking a little bit of time. We can make that motion. Often the Supreme Court will grant that request and stay all the lower court proceedings until the DJ is resolved so that there aren't inconsistent decisions floating around out there. This concludes, I guess, a general brief overview of the EUOs. We can get into more detail on specific sections, especially conducting the EUO. But for now, that's our overview. Christina, thank you for your time.
Thank you.
Have a great day. I'll talk to everybody soon.
Take care.
Bye.